as long as it was possible and open for passage, I was there. And other people passed there, didn't they? Yes. Quite a few people? Yes. As a matter of fact, that was a very busy thoroughfare, was it not? Very busy. Were there a crowd of people moving along there that morning? About 10, right around the spot that I was at, walking along with you, walking with me. Some in front of you, certainly, and walking about the same speed that you had been prior to the time you saw the train? I think so, yes, sir. Then, when you saw the train, you said that you accelerated your speed a little bit, just a little. Would you say that you were running? No. You weren't looking at a newspaper, were you? No, sir. Or watching the train? No. I saw the train coming into the station. But I mean, that's not when you fell, was it? No, no. Now, from this point to the station, how many feet would you say that is? I should say about 40 or 50 feet. You had to swing all around a curve, and then you first made the west side of the station, didn't you? I was past the curve. You were going into this curve? No, I was going past the curve to the straight walk. I mean, from this point to the westerly wall of the station is about 50 feet, about that. 80 jury charge, number 1. Mr. Foreman and gentlemen of the jury, in this case, the plaintiff complains he was unjustly apprehended and charged with a crime, that he was prosecuted by the defendants, that he has been damaged by this unjust accusation and by this prosecution, which he said lacked probable cause for either its initiation or prosecution. By this action, he seeks to recover compensation for damages he suffered because of what he says was done to him by these defendants. The defendants responded by denying that they made any accusation against him, and both defendants deny that he was either apprehended or prosecuted at the instigation of either one of them, and say that they are not responsible for any damages that may have been caused him by his apprehension, detention, or prosecution. Now, during the course of the trial, it became the function of the court to deny various motions made by counsel for the defendants to dismiss this action. By that, you are not to entertain the opinion that the court has an opinion upon the facts of this case under our system of disposing of cases. We divide the functions of court and jury. We, as it were, set up a barrier between the court and the jury. The jurors are the judges of the facts, and the court pronounces the law that is applicable to the facts of the case. Now, gentlemen of the jury, you may have notions of your own as to what the law should be or what the law is, and you may have gathered from the remarks of counsel during the summation what their opinion of the law is, bearing in mind that we separate the functions of court and jury. Dismiss from your minds what counsel told you the law is, or what you think the law is, or what the law should be. And even if you do not agree with the law, even though you do not think it is a good law, the court says to you that you must take the law from the court. Now, the plaintiff here has the affirmative. He has therefore imposed upon him the burden of proving to your satisfaction by a fair preponderance of the evidence. Jury charge number 2. Now the plaintiff here has the affirmative. He must establish these things by credible evidence of probative force, that is to say, by evidence that proves the fact, and if he fails in that he has failed to prove his case and may not have a verdict. Before he may have a verdict, you must find that the defendants personally directed or procured or instigated the arrest, apprehension, or prosecution of the plaintiff. The action of the defendants, as they say, in furnishing information to a police officer when called upon to state facts for his guidance, although such information is subsequently shown to be inaccurate, does not make the defendants joint actors with the police officer in making the arrest, unless you find that the action of the police officer was instigated or procured by the defendants, and that the police officer acted not upon his own volition, but to carry out a request of the defendants, or either of them, which was the procuring cause of the arrest, the defendants would not be liable. From that time the plaintiff was taken into custody by the police officer, he was subject to the control and direction of such officer or officers, and subsequently by the magistrate before whom he was taken, at the direction of the police officers of this city, and neither of the defendants had at any time thereafter a right to require either the detention or the release of the plaintiff, and cannot be held liable for the exercise of any judgment or discretion on the part of such police officer. If you find that the defendants did nothing more than simply furnish information to the police authorities upon which the latter acted, and that although there was a mistake in such information, it was furnished in good faith and simply for the purpose of aiding the police in apprehending a person apparently guilty of a crime, then your verdict must be for the defendants. To warrant a verdict for the plaintiff for a false arrest, you must find that the arrest was unlawful. To find a verdict in favor of the plaintiff against the defendants, or either of them, For malicious prosecution, you must find that the plaintiff has established that such prosecution was instigated by the defendants or either of them maliciously and without probable cause. A malicious prosecution, gentlemen, is one that is begun in malice without probable cause to believe it can succeed, and which finally ends in failure. Probable cause is the knowledge of facts, actual or apparent, strong enough to justify a reasonable man. This is a 72 voice. Okay, ready? Now, can you tell us approximately how much in all kinds of merchandise you bought from her approximately each year? Well, about $350 to $400 a year. And did you ever visit any of your neighbors' homes and see any merchandise there of the character that she sold? My sister-in-law, in your presence, did anybody that you can recollect buy merchandise from her? Only when I went over with her to my sister-in-law. That was the time. What type of lady was she, as you remember her? In which way? I want to finish. Was she, at her age and for her age, a very old, decrepit lady, or was she active, very active? Did you ever have any trouble with her, having her understand and hear you? Not at all. She was a wonderful woman. Did she ever, in your presence, write anything, any memorandum down? Yes, of course, she had to put numbers down, and she would write. Did you ever watch her do that? Absolutely. Did you ever notice whether she ever had, during all the years you knew her, any trouble in seeing? Not at all. Not that I know of. Did she ever have any trouble in coming to the doorway after leaving you? No, not at all. I understand you to say that this lady would come to your house with some merchandise, and rather than have her go away, you would buy something. Is that right? Yes. In other words, she always brought it with her. Did she? Yes, the goods. When you say that rather than let her go away, you would buy $3 or $4 worth each week. Is that right? Yes. How many sheets would you buy for $3 or $4? Well, you see, no. Tell me that now. How many sheets would you buy for $3 or $4? Well, I have a 13-room house. Two voice. Ready? Mrs. Jones, the defendant is your father? Yes, sir. Do you recall the 10th day of October, 1993? Yes, sir. Were you with your father during the evening of that day? Yes, sir. Do you recall where you met your father? I do. Where, please? At his office. Where is that? 6th Street and Broadway. And was anybody else with you? I was in company with my mother. And your mother was with you when you went to your father's office? Yes, sir. Did you leave the office together, the 3 of you? Yes. How did you leave? By car. Whose father was it? My father. Was it this particular car that was involved in the accident? Yes, sir. When and where? I had seen it that morning when I opened the garage door for my father to let him get the car out. And did you notice the appearance of the car at that time with respect to the condition of the mud guards and the body? Yes. What was the condition? They were all right. Did you see it the evening after the accident? Yes, sir. I show you Defendant's Exhibit B and ask you if that is the condition of the car as you saw it on the evening immediately after the accident. Yes, that is the condition, the way I saw it. Now, you left your father's office about what time? About 6 o'clock. And who was in the car? My mother and father and myself. And where were you sitting? I was sitting in the rear of the car with my mother. On which side of the car were you sitting? The right or the left? Facing forward? On the right side. Whether both drivers were guilty of negligence, which substantially contributed to cause the accident, or if weather conditions alone were responsible. Should you find that both drivers were guilty of violation and the violation by each was a proximate cause of the accident, then neither party can avoid liability. Gentlemen of the jury, the plaintiff filed this action in the district court of this county and alleged that on the 18th day of June, 1926, the defendant, in consideration of the annual premium set forth therein,